Okay, so the structure today is very simple. Oliver's going to take a lead now and talk us through the ruling. Then we'll invite Demi and Gail to share some of their personal reflections from perspective of advocacy, and then we'll facilitate some Q&A. So if you've got a question, stick it in the Q&A, and then we will just work our way through as best we can. Oliver, welcome.
Thank you very much. Kate, thank you very much for inviting me, and it's a pleasure to speak to so many advocates. We've got, I think, around 400 people, so it's absolutely magnificent. Congratulations to Kate for bringing so many people together who are obviously very concerned about the judgment. So let me just recap on what the judgment says and what it does and what the impact is for people who last Monday were described as being deprived of their liberty. First, I need to give a sort of health warning about some of the comments on social media, including on LinkedIn, where people go on and try and interpret the judgment. And some of it, gosh, my camera keeps turning off. Apologies. Some of that commentary is clearly wrong. There are comments like, especially from social workers, who are very well intentioned, I'm absolutely sure, but say, well, if we just carry on and doing proper capacity assessments and follow the MCA best interest decision making process, then everything will be fine and there won't be much change. So that is clearly wrong. It's also clearly wrong to suggest that I've seen some organizations saying that local authorities don't really need to do anything, don't need to review anything, and they should just carry on as normal. That's clearly wrong as well. So please be careful. So this is not an exception to fake news and people's opinions, however strongly stated. You should just bear in mind that some of those opinions are clearly incorrect. So with that said, it's really difficult for me to explain to you how extreme this judgment is and how far-reaching and what a sea change it actually will or is already bringing about, and what a huge impact it will have on people's rights. There is no getting away from that. So, as you probably all know, the Supreme Court last week set aside its previous judgment in the 2014 case of which become known as Cheshire West, which established the so-called acid test, and that was the acid test was just the moniker that the court, and in particular Baroness Hale, used to describe the two elements to figure out whether someone's deprived of the liberty. And as we all know, the two elements were is the person subject to continuous supervision and control, and are they free to leave, including if they tried to leave, would they be stopped? And so that was very simple, and it was operationalizable, if I can put it like that. However, of course, it did result, as you all know, in a lot of work for local authorities and for care homes, and the administrative burden on the state was actually the reason why this case last week was initiated by the government in Northern Ireland, and then the Scottish government, and the Westminster government jumped on this bandwagon, and actually the Westminster government, which is responsible for England and Wales, in this area at least, they asked the court to go much further than the Northern Irish government had asked the court. So what is now the law? And again, a bit of fake news is that some people say this isn't law. We have to wait until legislation, or we have to wait until guidance. Well, that's clearly incorrect, because we live in a common law jurisdiction, and if there's a Supreme Court judgment, that is the law. That's the interpretation of the law, the interpretation of Article 5 of the European Convention on Human Rights. The Supreme Court's judgment is the law. And so, while of course we're in this period where we're all waiting perhaps for the Department of Health and Social Care and Ministry of Justice to come out with guidance, that guidance has to follow this law. It can't depart from the Supreme Court judgment. And it will be guidance only. So instead of the acid test, which was quite simple to understand, we've now got a so-called multifactorial a decision-making process to figure out whether or not someone is deprived of their liberty. So those factors include the degree of supervision and control, the effect of the restrictions on P. Does P experience the restriction as a major intrusion in their lives? The duration, and the purpose. And interestingly, I think this is one of the interesting elements because it's so contrary to what we know about the nature of disability, the nature of institutionalization, the nature of relational influence, etc. And so the Supreme Court says that the relative normality of the placement is going to be relevant. And they say if the individual is living in their own home in accordance with their wishes and feelings, it makes it less likely that they're subject to a deprivation of liberty. Put another way, the restrictions imposed would need to be more severe or extensive to amount to a deprivation of liberty, such as a combination of restraint, medication, and seclusion. And then they say that where measures are far from confinement in a prison cell, then the therapeutic purpose may make it less likely that a measure is a deprivation of liberty because it's going to be deemed more proportionate. The restriction is going to be proportionate to achieving the relevant purpose, which in our sector, in the disability world, the purpose is never going to be described as punishment, is it? It's always going to be described as therapy or care, safety, that kind of thing. So I thought
Oliver,
that,
sorry to
yeah,
interrupt your flow. Are you, should we be seeing slides at the
no,
moment?
I don't have any
No,
slides. Sorry. Yeah,
just
I
wanted to
just thought
check.
I'd just talk through. Um, and yeah, so I think that's a very interesting part, and they go on to say that coercion needs to be a necessary element for deprivation of liberty. So they talk about the stress for P in having their objections overruled may lead to suffering and result in the use of physical force or physical restraint, and that those features of the person's concrete situation are likely to be clear indicators that they're being confined in the sense of suffering a deprivation of liberty. And that is quite telling in the way that they describe that, right? They call it the suffering of a deprivation of liberty. Whereas last Monday and since Cheshire West, no one really described being deprived of their liberty as suffering because it was just a plain English description of the situation. And then, of course, the dole had to be authorised, and there's no necessarily any suffering involved in that process at all. But the Supreme Court have completely reframed this, and so I think that the factors that I've talked about so far are really nebulous and often going to be quite circular and quite easy to say, well, that doesn't apply, that doesn't apply, that doesn't apply. The care home doesn't look anything like a prison cell. It's normal. It's relative normality. It's normal to put people with dementia into a care home. It's normal to have closed doors because that's related to the person's disability, to keep them safe, and the purpose of that is therapy, care, and preventing harm, and it's not at all punishment. So nothing to indicate that the person is deprived of their liberty so far. But one of the things that the Supreme Court talks a lot about is the person's wishes and feelings, and the presence or absence of objection, including giving a tacit agreement, might well be relative and relevant, and I think it might well be determinative in many cases. And they say that the person's subjective attitude, as so expressed, carries significant, indeed usually decisive weight. And so if a person has a view that they do not accept their situation, that opinion should be respected and will usually lead to the conclusion that they are deprived of their disability. And you've seen lots of commentary online probably to say that this is quite the departure from not just Cheshire West, but it's a departure from how we understand consent in many areas of the law. And essentially, the Supreme Court has introduced a new concept into law, one of incapacitous consent. So you can lack capacity, and everyone agrees that you lack capacity to make decisions about residence and care, and yet you can, in your incapacitous state, indicate your consent to your living arrangements. So that is an entirely new concept, and lots of disability campaigners say that's a very dangerous concept to introduce. And then the response to that by some other commentators is that, the response to some of the charities that I and others represented is that, the charities don't are not respecting P's wishes and feelings, right? Like, their we should always respect someone's autonomy. That's the response. So yeah, I'd be interested to hear your views about that. So, so that's what the Supreme Court judgment says. What does that mean? What does it all mean for the right of someone to have advocacy in certain circumstances? Well, obviously, it means that in the hospital setting, there will still people be who will be deprived of the liberty while waiting for a discharge destination, especially in circumstances or maybe only in circumstances where they're objecting and they, for example, want to go back home, but it's completely not possible for them to go back home, but the local authority and ICB, for example, have not arranged a discharge destination. So there'll be fewer people deprived of their liberty in hospitals. There'll be far fewer people deprived of their liberty in care homes. I think that we'll see cases like a person with dementia in a dementia setting who's really objecting in that period of their so-called dementia journey when they are objecting. I think we'll see people deprived of their liberty who are younger people with autism or acquired brain injury, for example, that means that their behaviours pose some quite significant risk to themselves, and that they might be subject of doing risky things in their home or in the community. But I think that quite soon we will see a rapid reduction in the number of standard authorizations. Apologies about my camera going on and off. That's not me turning it off, but it is me turning it back on. And in the community, I think we'll see an almost complete drop off of deprivations of liberty, because there are going to be very few people who are genuinely objecting to their living arrangements in community settings, such as in their own homes, in their family homes, or in supported living arrangements. There will be some, but the vast majority of those authorizations are for people who are not objecting or don't demonstrate any sort of unhappiness. And so we will see way fewer standard authorizations under Schedule A1. That means that there won't even be an RPR appointed. There won't be a best interests assessor, BIA. There won't be any Part 8 reviews because the person won't be in the arena of Schedule A1 at all. So I think the guidance will have to say someone will do it won't use the word cursory, but someone will do a sort of assessment to see whether the person is objecting and do some sort of multifactorial checklist. And if there's no indication that the person's really objecting, then Schedule A1 won't really be necessary at all. So they won't have any access to advocacy. And my worry is that, and I would love to be optimistic. I am an optimistic person, but also as a lawyer, I just can't see how Care Act advocacy or IMCA advocacy can replace RPRs or Rule 1.2 reps, because it's very difficult, impossible, without legislative change to map on the role of an RPR onto Care Act advocates. They do different things, also at different times. So if a person's in a care home, they will already have had a needs assessment, right, which indicates 24-hour care. The care home will have been identified. They will already have a care and support plan. So those are the two sort of trigger points at which someone might be eligible to have a Care Act advocate. So I fear that there will be thousands and thousands and thousands of people who might be not very happy, but not positively objecting for all sorts of different reasons that you can think of, I'm sure, who will not have access to an advocate. They will also then not have access to a quite effective and straightforward procedure to challenge their deprivation of liberty in the Court of Protection. They won't have access to legal advice. They won't have access to non-means tested legal aid. And in my view, that we will inevitably, sadly, see more, or maybe we won't see because they'll be hidden, but there will be more cases of abuse, exploitation, violence, neglect, all of the things that are prevented by safeguards being in place. And I say that we won't know about some of these because there will be fewer visitors. If there'll be a fewer kind of independent visitors to care homes. So Kate and I think, were discussing the other day, well, maybe one of the strands is more community activism, like we see in children's homes, prisons, and maybe we need to think about activating the community to visit people in care homes, to meet people who will no longer have any legal resource to any forms of advocacy. So sorry, that's really, really depressing, but that I think is the reality. I'll stop there for the time being.
Thanks, Oliver. Okay, so we're going to spend a few minutes reflecting on our responses to what's happened. Demi, Gail, would you like to share your thoughts?
Thanks, Kate. Do you want me to go first, Gail? Yeah, no worries. So I think for me, the first thought to come out of this was the huge amount of vulnerable people that will now not be viewed as being deprived of their liberty, particularly people that are now viewed as not being deprived of their liberty as they can't conceive of leaving and physically can't leave. And so because they're not being stopped and deprived of their will, there is no dole. And also just the potential lack of safeguards and advocacy involvement for a lot of the people that we as advocates are currently supporting as RPR, thinking about people we've supported via a non-instructed advocacy approach, but have still been a really important safeguard, people that have no other visitors, and as RPR, we're the only person that's visiting regularly, one of the few forms of any external scrutiny. And we've been able to challenge decisions such as, Article 8 related issues and push for things to really improve a person's quality of life. My second thought was that there's a lot in the judgment that needs clarity in terms of the guidance that we'll receive, but it does seem that there's now a potential lack of external scrutiny and safeguards for people. Who's going to be responsible for conducting that multifactorial assessment and when? Will this be solely down to the care home managers, bringing back concerns raised during the early stages of LPS? Will there be any external scrutiny on that from local authorities? And what about the consent element? How is that going to be identified? Again, is that just down to care home managers? And is there going to be any system to keep that consent under review, as was envisioned in the Northern Ireland Code of Practice? What happens if people change their mind or no longer have the basic understanding that is needed to be able to consent, in inverted commas, and what is required to have that basic understanding? It seems clear that people that are objecting are perhaps more likely to be determined to be deprived of their liberty, and those that are aware of where they're living and can provide some form of consent are not deprived. But what about the people that don't fall at either end of that spectrum? At the moment, without examples, guidance, and test cases, at the moment, it seems a little bit unclear who will be viewed as being deprived of their liberty. Thinking about people that don't actively object, but also don't express positive views, either because they can't, or people that feel they have no choice but to be compliant, or don't necessarily express their true feelings to care home staff for fear, for want of a better word, of what consequence that may have. People that maybe like where they're living but object to some restrictions that are in place, They might want to go out for a walk to the shops, maybe object to personal care. Also not clear how the test will be applied. Will the subjective element be looked at first in terms of whether people are able to consent? And the judgment talks about the subjective and the objective elements having an overlap, but only the subjective element seems to require the person to have that basic awareness and more than mere acquiescence. Is a passive acceptance enough to negate the impact of restrictions on someone, so as to say that they're not deprived? And what about relative normality and the purpose of the restrictions when these are far removed from a prison cell? As Oliver was saying, the judgment talks about how they don't consider the objective element to be made out in the case of Meg in Cheshire West, because the purpose of that continuous supervision and control was to meet care needs, not to keep her prisoner. And any restraint was used to protect her or others, not as punishment. So, as Oliver said, is that not the purpose of all care settings? And can we really say that living in a care home with their routines, locked doors, lack of choices that people have is really normal? The guidance might address some of those concerns, but I think on reflection, it's the biggest concern I've had is the concern that people won't have the safeguards in place, and a fear of what will go unnoticed and unchallenged that has been the main thing I've focused on, and what we can try and do to make sure as many people as possible still have access to advocacy support. The judgment talks a lot about other safeguards that are in place for people, such as their entitlement to a Care Act advocate. And whilst there is an opportunity for us as advocacy providers to ensure we're doing everything we can in terms of Care Act advocacy, promoting referrals and reminding local authorities of their duties to refer, and there's maybe some potential to try and redirect some of that resource, in reality, we're not seeing that every person we are supporting as RPR is eligible for a Care Act advocate, either because they are people who are settled and there's no change in their care needs, and so reviews under the Care Act aren't taking place. Even if they were, Care Act advocate may not be involved long term, would then cease to be involved until the next review, which would potentially be at least a year away unless there was any change in need, and how much could happen or change in that year. There will also be people who have had a paid RPR because family haven't been appropriate or haven't wished to take on that role, but family would be an appropriate person for the purposes of supporting through a Care Act review. And there's also many people who we support as RPR who are still self-funding their care, and the only involvement they have from the local authority as a supervisory body. So there are so many people that we support as RPR, but don't have any other statutory advocacy involvement with. Therefore, with fewer people being determined to be deprived of their liberty and under a standard authorisation, there will be so many people that advocates just aren't coming into contact with through statutory advocacy. So any suggestions that we try to think of to go some way to try and bridge that gap are likely to fall outside of a statutory advocacy remit and be non-statutory, more community forms of advocacy. But then we have the challenge of how willing commissioners are going to be to fund that.
Thanks, Demi. That was great. Gail.
Thanks, Demi. I mean, I think you've probably talked about quite a lot of the things that have come up for me with my initial thoughts and reflections. And I guess picking up on something that Oliver said right at the beginning, I'm really mindful that the judgment's very complex and that we are seeing so many interpretations of what that judgment might mean in reality. And at the moment, in the absence of the guidance that we're waiting, a lot of that feels like conjecture. I mean, I think even just reading the comments and the questions, I think shows that varied, totally understandable, varied understanding of what the judgment actually is going to mean in reality for people. Regardless of that, we do know, don't we, that far fewer people are going to be considered to be deprived of their liberty. The things that I guess have concerned me the most are the concept of valid incapacitated consent. And I'm a bit long in the tooth and remember working really hard on the development of the Mental Capacity Act and lots of conversations around implied consent, tacit consent, and the weight that we put on the development of a structured approach to best interest decision making where people lack capacity to understand the decisions that were being made around them. And from my perspective, that legislation was always designed to be an empowering piece of legislation that gave people rights to make their own decisions as far as possible, but also gave a structure and provided accountability for decisions that were being made where people did lack capacity. And so for me, the bit that I'm just still reeling with really is that there's one enormous area of somebody's life, like being confined within a setting. I now don't need to actually have the ability to understand that for somebody else to consider to me to be consenting to that. And for me, that's just mind-blowing, profound, concerning, and actually to some extent feels like it undermines in some ways people's Oliver, it was really interesting listening to you talk about the kind of weight that's going to be put on people's views, wishes and preferences. What I'm grappling with is that about the views, wishes and preferences I can express in this moment, as opposed to my previous views, wishes and preferences. And I can think of people that I've supported over the years who would not be able to object in this particular moment, but would absolutely 100% consider themselves to be deprived of their liberty. And how do we grapple with those things, and how do we make sure we're really considering those past, present wishes, feelings, views, preferences? So yeah, huge concern about valid consent, and like Demi and Oliver, you know, relative normality in a care setting. And I think my worry is that we start to say it's fine to keep people in restricted environments. It's fine that people's independence and autonomy is compromised, when we know actually people always do so much better. The more autonomy, the more support they have to live lives as they want to live. So this idea of relative normality and confinement, and yeah, still really, really worried, still really keen to see how that's going to play out as we move forward. My other reflections are about how we as an advocacy sector kind of respond. So I think one of the things that I see is amazing RPRs, paid RPRs, visiting people. And I think something that might have happened over the years is that the role that RPRs is filling has kind of expanded beyond what the original plan and intention was. So RPRs might be picking up all sorts of other restrictions that people are facing in people's care and treatment that aren't picked up anywhere else because they're not an eligible decision around that an IMCA might pick up. They might be a part of someone's care planning, but they might not be. And so I think RPRs have been playing this much broader role, picking up safeguarding concerns, picking up practice concerns around the quality of care, picking up concerns and getting involved when there are other kinds of restrictions being imposed on someone. And I think we need to, as a sector, demonstrate that and find some ways of our resource still being able to be directed to continue to do that. I think our approach to the commissioning and delivery of statutory advocacy has led to us often seeing advocacy as quite siloed roles. And I don't think that was ever the intention with many of those roles. The view was always about, okay, you've got some rights to advocacy at these particular moments, but that should be in the context of a broad advocacy offer to people. And my real hope and aspiration is that as a sector, we can lead the discussions with our colleagues in local authorities and with colleagues in Department of Social Care, Department of Health and Social Care, around how does that RPR resource that we've currently got with those skilled people, how does that get redirected so that we can still make sure we're providing some appropriate safeguards to people and people still have access to that independent support and representation? There's more, isn't there? There's so much more, but I'll stop there because, yeah, I'm sure other people have got more to say. Last thing, I guess, actually, is with the acid test and with the Mental Capacity Act two-stage capacity test, you know, those were relatively straightforward, simple concepts to apply. and we still got it wrong frequently. And so my concern is, how on earth are we going to navigate this multifactorial test? I mean, I'm not a lawyer. I feel like I've had a good handle on people's rights within the legislation, and I'm really struggling with understanding how this is going to be applied in practice in an easy way that upholds people's rights and continues to be empowering in its approach.
I think you're in very good company there, Gail, with that concern. So we've got quite a few questions. There's a few themes. If I kind of walk us through some, Oliver, and I'm going to ping them mainly at yourself. I think there's a couple around rights to appeal this. I think that's an easy one to answer. I thought there was a
Rights to
clear
appeal this
indication
judgment.
of preference there. You leaving?
Yeah.
Yeah, there's been like, can it appeal? Can there be? Do you just want to
I
talk
think
us through
my
kind of why
reading-
that can't happen?
Yeah, so the Supreme Court judgment cannot be appealed because it's the Supreme Court, and we can't take we can't make an application to the European Court of Human Rights because this was a technical legal question that the Northern Irish government asked the Supreme Court. There weren't any human beings behind it, so there's no so-called victim. So there's no application can be made to the European Court of Human Rights. Someone asked a question about whether you can appeal, like, a needs assessment and things like that under the Care Act, or needs assessment might have been done without family involvement or an advocate, and what can be done. I mean, almost nothing can be done about that. If the needs assessment was done accurately, then no one's going to be concerned that there was, I mean, maybe apart from you, but no one, the social workers and the care home or provider is not going to be concerned that there was no advocate involved. Yeah.
Thanks, Oliver. Another theme across a couple of questions is kind of the immediacy of what now, like what happens in the next few weeks to the DOL's authorisations. Do they stop? Should paid RPRs and advocates just continue until they're told differently?
Yeah, well, so if there's a standard authorization in place, then there needs to be an RPR, right? And we will see local authorities terminating standard authorizations in the next few weeks and months because they will, pursuant to this judgment, decide that the person isn't deprived of their liberty. And they are the organ of the state that, it's in their gift to grant a standard authorization or terminate them. And the result of the Supreme Court judgment will be that thousands of standard authorizations will be terminated, obviously, because the test of figuring out whether someone's deprived of their liberty or not has radically changed. So if there's no standard authorization in place, then the RPR role falls away. There is no RPR, right? But the RPR should continue to provide their services during the currency of a standard authorization. Yeah. And same with Rule 1.2 reps. If there's a court of protection, I mean, until notified otherwise, then they should just continue doing their role. But they will be, like, the tsunami is coming, right? They will be notified, and we will see over the next weeks and months. Some local authorities that I've spoken to and I've advised are going through their list of people under standard authorizations, are figuring out how to kind of re-interview people, are categorizing them into kind of priority cases or low priority cases, and starting with the kind of low priority ones where they're pretty convinced that P is not going to be able to or will not object, and they'll start with those and start terminating those authorizations. Other local authorities have decided to wait until there's guidance, and I noticed that ADAS have recommended that. I don't personally think that is sound legal advice, because the law is the law, and yeah, it has immediate effect. So that, I think, is quite suspect legal advice from ADAS. Well, they're not providing legal advice; they're basically advising local authorities what to do. And that would certainly not be my advice, because the local authorities do have to ensure that no one's unlawfully deprived of their liberty after the Supreme Court judgment. Yeah.
A couple of questions, and maybe if I bring in Gail and Demi, a couple of questions around a bit longer term, when advocates are going in, so in our brave new world, the person doesn't have a dolls because they're happy and they give, this, they appear to be content and happy with what's happening. The advocate comes in, notices actually they're not, that there is some objection. What should the advocate then trigger? Is it a request for a dolls assessment? Is it a Care Act review? Is it a safeguarding? Anyone got any thoughts on what that could look like? Gail, do you want to maybe take it? I'll just give Oliver a chance to have a breath.
So, Kate, say again.
So in the Brave New World, you've got somebody who doesn't have a dolls.
I think it's probably requesting a dolls assessment, isn't it? But I also think we're just going to have to start using all the routes that we have. So if you're concerned that there's a safeguarding issue, regardless of requesting a dolls, you raise that safeguarding concern. Don't hesitate if you're concerned about restrictions potentially impacting on people's rights. Raise the safeguarding concern. Ask for the Care Act reassessment. Ask for the dolls assessment. I think we need the guidance. Otherwise, we're just sort of guessing at the moment. But I think you use the routes that you have, and absolutely, if you're concerned that somebody's care is it's of a standard that warrants a safeguarding concern, or the restrictions are such that we need to explore under safeguarding, then you raise that safeguarding. I think there's.
And it seems to me to be a very sensible thing for the guidance to cover is, and a few people have commented about timescales, just because somebody's happy in January doesn't mean they're going to be happy in May. At what point could that trigger for another dolls consideration be made? So that's really critical, isn't it?
Can I come in?
Advocate, you need to be alert, the antennae need to be up. Oliver?
Can I come in? Yeah, so I think there'll be interesting cases that we'll see as this sort of like is implemented, where the local authority will have done this kind of like initial screening and say, okay, well, P's not really objecting, so there's no dole. And then an advocate goes in to visit someone else and happens to have a cup of tea with this person, and they indicate that they're not happy. And what role does that advocate of someone else have to sort of alert who? Because if they alert the dolls team will say, well, thanks very much, but we've already kind of like, we know about this person and they're not objecting. And so Gail made really good points about the longitudinal differences of people's opinions, right? Last week I could have been objecting, and this week I'm fine, or vice versa, etc. But also we know that it's very, very common that someone especially in an institutional setting or in a care relationship, will tell their carers or social workers one thing and then say different things to an independent person or their family members or another resident or a mate or a childhood friend or whoever it is. And that's going to be something that we need to absolutely look out for, because it will fall on essentially care providers to notify the local authority if someone's objecting. And as Demi also said, that there might be a myriad of reasons why someone would not indicate an objection, because they just want to, they think that they should put up with their lot, or they think that they're not the sort of complaining type of person, or they might be fearful of some sort of low level or high level retribution. Or they might have become institutionalized, or they might be a person with a learning disability who wants to give the answer that the person asking the question wants to hear, or they might be a person who is with a family member and give an answer that they think the family member wants. There could be all sorts of ways in which people express their views to one person, which isn't the same as expressing it to another. So this whole concept of incapacitous consent is incredibly dubious.
It's very difficult to understand, isn't it? At this point, I'm gonna speak to the advocates in the room. Okay, so if you're an advocate, one of the things we need to be doing more of as a community is something called place-based advocacy, residential visiting advocacy, group advocacy. I don't care what you call it. It means being present in the places where people live. You need to find a way of getting into these institutions, settings, whether it's a mental health hospital, general hospital, care home. You've got to move away from siloed, meeting-driven, decision-driven moments of people's lives. We've got to have relationships with people so that we know when somebody changes, when you will notice when somebody becomes unhappy. So it's one of the big things that you've got, redirecting the RPR resources into this sense of regular visiting to a place. Hidden people are going to be more hidden because of this, without a shadow of a doubt. And I think that's terrifying, given all the closed culture scandals that we've had in the last 20 years. Advocates, you have a beautiful, beautiful, powerful role to play in countering that. But you've got to be there. You've got to be there. The idea that Oliver just described, if you go to see Jeff and you notice Tom, we don't always have the luxury of doing that. What I'm saying is, don't make that luxury, make that a must. Give your advocates the time and space to go in and see people and just spend time having that cup of tea. Back to our questions. Okay, should we go for a techie one? Lynn, I'm just going to go through them in order, Oliver.
Can I just chip in about that? Because I think there's lots of comments in the chat about, oh yeah, but who's going to pay for that? You're already, I think there's something about, as a sector, really demonstrating the broader impact that you have as advocates in all roles and all hats. So we know, don't we, that as RPRs, you're doing so much more than that RPR role. And I think we've got to, as a part of moving through this next journey, find some really good ways of articulating that.
Yeah.
So that we can make sure that resource stays in the sector and that we still are able to fulfill some of those safeguards. Yeah. Sorry, Kate, I'll let you get back to that.
Do we want a call to action? You're advocates. You're not quiet. And if you were a quiet advocate, then jog off. We want people confidently talking to Commissioner. The first thing I'd be doing is to be talking to Commissioner about redirecting that resource. The first thing I'd be, well, you can't have two first things, can you? Second thing I'd be doing is thinking about monitoring. What's my kind of, streamlined process? What's that Batman hotline to commissioners, to MCA leads, to safeguarding teams, that my advocacy team has a place to put these concerns? What does that look like in this brave new world? Be brave, be bold, you're advocates. You're really, really powerful guys. Don't be passive in waiting for that handout of, oh, there's no money. Find it. Honestly, find it. Step up and make this better for people. We can't go silently in the night on this one, can we? We've got to make it better.
Kate, can I just come in on that? I've just put in the chat a link to the judgment, which everyone will have anyway. But if you look at paragraph 10, the Supreme Court seems to think that there are safeguards for Article 8. And so I think the call to action to the government should be creating, the Article 8 safeguards don't exist, everyone knows that. But given the Supreme Court says that there should be Article 8 safeguards. So, for example, if a person is subject to any form of restraint or restriction of contact with others, or PRN medication potentially, that sort of thing, then all of those interventions could be said at least to engage the person's Article 8 rights, Article 8 of the European Convention on Human Rights, the right to private respect for private and family life, home and correspondence. So there are no advocates looking out for people's Article 8 rights, and so the redeployment has to be pegged to some kind of statutory provision. Otherwise, local authorities are obviously not going to fund it. They're not going. Local authorities, as you all know better than me, are absolutely cash strapped, so unless you've got some incredible altruistic and brave local authority chief exec and councillors, I don't see how current resources are going to be redirected. And I think the call to action should be for an expansion of the IMCO role into Article 8 territory, and that would have to be done by Parliament. And I think there should be a national campaign calling for Article 8 safeguards, because that is something that the Supreme Court says effectively should be in place. So that would be my suggestion to the advocacy world. And I think Gail made a really good point, which is demonstrate your impact. And what we're doing, just if I could tell people, is working with Rightful Lives, who are going to be hosting part of their website. It's going to be to capture the cases where there's been a good outcome, and where bad things have been exposed, and hopefully a good outcome has been achieved in the Court of Protection under Section 21A applications, or under COPDOL 11 community deprivation of liberty cases, for a person who might now not be classified as deprived of their liberty. So those cases are not going to happen in the future. And while people's memories are fresh, whether you're a social worker, an advocate, a lawyer, a Court of Protection judge, we're asking people to kind of contribute their stories, so that we build up a bank of exactly what Gail described, which is impact.
Beautiful. Thanks, Oliver. We can take that to leaders, can't we, Gail? Or you can, yeah. Okay, technical one from Matthew. Great question. If a person in a care home is no longer under legally authorised deprivation or confinement, does it mean a friend or family member can now just take them home?
No, because it's about, if the person lacks capacity to make a decision about residence, then it's a best interest decision-making process, right? So you regular MCA stuff, you follow Section 4 of the MCA, and another adult, a relative of someone an adult in a care home, unless they have attorneyship or deputyship for that person's health and welfare, has no legal right to make a decision for that person. So you need to follow the MCA. And if there's a dispute between care home or local authority, family, P, the only body that's capable of resolving that dispute is the Court of Protection. So someone must make an application to the Court of Protection for a best interest decision.
But I guess the question is, on what grounds are they preventing the person from leaving? In the past, it's been because there's a deprivation of liberty saying the person has to stay here. So do you think that will just be weakened to best interest decisions if said the person has to stay here?
But the DOLS is about best interests.
Sorry, yeah, but
yeah. So for paragraph 16 of Schedule A1 to the Mental Capacity Act, is this person a detained resident, and is it in their best interest to be here? So DOLS is already about best interests.
Okay,
yeah, and so if everyone agrees that Audrey can go home, and she lacks capacity to do so, and she wants to, she's indicated a wish, then fine, you don't need to make an application to court. But that's you have to follow the MCA best interests regular decision-making scheme.
Quick one, how is own home being defined? Supported living, shared lives, group homes? I don't think there's been any change to that, but is there anything further on that, Oliver, that you can give?
What? Sorry, own home?
Yeah, it's the first question on the Q&A. I'm just going through them in order. So
okay.
The question is, how is own home being defined? Supported living, shared lives, group home?
It's not defined in the it doesn't feature in the Supreme Court.
Doesn't touch it, does it? No.
So I think just a recap, Schedule A1 is the DOLS regime, right? That only applies to hospitals and care homes, right? In England and Wales. And everything else is sort of in the community. That includes in the person's own home, in their parents' home, in shared lives, in supported living. And if a person is deprived of the liberty there, that has to be authorised by the Court of Protection, right? So a local authority can only grant a standard authorisation under Schedule A1, the DOLS regime, for people deprived of their liberty in a hospital or a care home. Hope that helps.
Thanks. I think some of these are quite standard ones. So Jacqueline's asked, do we still need to request a Form 4 from the dolls? This is the doctor's assessment. I mean, yeah, there's no change, is there?
No, there's no change to the dolls regime at all.
No change.
So if a person is deprived of their liberty,
Yeah, it's the same
then
forms, same process.
yeah, the forms might be changed in the future. And what we were suggesting is that if dolls is an administrative burden, then make the forms shorter. I mean, some of these dolls forms, as everyone knows, are ridiculous. So repetitive, like 25 pages when they could be 5 pages. And everyone would be pleased if they're much shorter to reduce the administrative burden. So they might be redesigned. We'll see.
Question comment from Tasha. One concern I have with community dolls is that people supporting on the ground often forget support needs to be least restrictive. If there's no annual review or Rule 1.2 rep, how will people be supported to ensure their care and support is appropriately least restrictive in accordance with legislation? Demi, Gail, any thoughts on, or Oliver?
I mean, that's exactly my point about advocates, RPRs, Rule 1.2 reps, picking up a broader remit. That's exactly what's happening, isn't it, in those instances? And back to impact, go back, record all those instances where you as RPRs, 1.2 reps are raising safeguardings, raising issues around restrictions. You know, that, I guess that's my point, but other people will have other things to say.
I think that's fine. Thanks, Gail. We've still got quite a few. I'm going to whiz through them. Thomas has asked, will care homes, this is interesting, will care homes be at risk of become liable for unlawful detention, false imprisonment, if a local authority doesn't put in place a doll authorisation for an objective resident? So what happens if they get it wrong, I guess? Is that what you're asking, Thomas? Could this offset a trend to put fewer people on dolls? Any thoughts on that?
Highly unlikely, because judges are not going to want to penalise care homes for doing something which the local authority has okayed, right? And because it's now so wishy-washy and so essentially subjective, I think unless there's some kind of like extreme case where it's obvious that someone's kicking and screaming and objecting, and the local authority doesn't do anything about that. But those cases don't really exist, hopefully, or very rarely. I think you're not really going to see a judge in the King's Bench division saying, this person was unlawfully deprived of their liberty. I think those cases also will settle really quickly, because local authorities will not want those cases to be exposed in court.
Okay. Don't think a comment, but it might trigger not a question, but it might trigger a comment, Oliver, from you. Gary's asked, I wonder how much of people's frustration is less about whether Article 5 is being engaged and more about the safeguards no longer being present. My concern is standard authorisations have masked the state of adult social care since Cheshire West, and there has been an over-reliance on engage in Article 5 purely for the safeguards, where Care Act reviews, JR, health and welfare applications to the COP could also actually be used. Any thoughts on that?
Yeah, I don't accept that at all. All of those other procedures that have been mentioned, what the Care Act review, I mean, how many of those actually happen, and what is that? The Care Act looks at a person's eligible needs under the Care Act. It does not look at this through a human rights lens or restrictive lens, etc., etc. And hands up who's successfully judicially reviewed any decision in adult social care.
Yeah,
that's just not an available, an effective option for someone. So I absolutely do not accept the premise of that question.
Okay. Stefan's asked, will we be in a situation where effectively the managing authority and latterly the supervisory body will be the ones deciding whether and to what degree a person has an awareness of the situation they are in? A few people have commented about, people marking their own homework. Any thoughts, comments?
This will have to be set out in the guidance, won't it? Because I don't know none of us know what the process should be to implement the Supreme Court's judgment. There'll have to be some kind of initial screening. I've described it as cursory. but there'll have to be some kind of like pre-screening before you get into doing all those assessments under Schedule A1, because you need to know whether the person's actually deprived of their liberty. Because if they're not, then Schedule A1 doesn't apply. So we'll find out hopefully through the guidance. I don't know whether, I mean, there'll have to probably be some local authority input. It won't, yeah, maybe they'll describe it as a supervisory body at that point. Maybe because LPS also would have changed the system and placed much more emphasis on the care provider doing an initial assessment. And I've heard, by the way, on the issue of liberty protection safeguards, that actually the government is wondering whether they need to switch that on at all, because there'll be so few people deprived of their liberty now, especially in community settings. And you might as well just tweak Schedule A1 a little bit to include community settings, because there just won't be very much work, because in reality, very, very few people will be deprived of their liberty.
Because of the time, it's 10:30. Should we just do 3 more and then we'll call it? Question about young people. Will this impact on young people any differently? Any thoughts?
So it doesn't address under 18s, but it is an authoritative interpretation of Article 5 in the UK. So we'll have to see how courts interpret this Supreme Court judgment in under 18-year-old cases. I think the legal community thinks that it will have an impact. I mean, one of the examples given was in the family division, a 12-year-old case. But all they were, the Supreme Court judgment in legal terms was about adults. So we'll have to wait and see what happens to children.
Thanks, Oliver. How does the judgment and decision about consent overlap with responsibilities of those who hold deputyship or power of attorney? Especially where the deputy can effectively speaks for the person. Is it the deputy that's listened to, or are they ignored? So I guess if the person's okay but the deputy's objecting, or vice versa, any thoughts on what should happen?
Yeah, sorry, it's not correct to say that a deputy speaks for a person. The deputy, if they're a health and welfare deputy, they don't speak for the person. The person speaks for themselves, and the deputy takes best interest decisions for or on behalf of that person. And so there is I can't remember which paragraph, but there's a curious paragraph in the judgment which seems to suggest that a deputy who has legal authority to make best interest decisions might consent to confinement. That's not really spelled out. That would be a significant departure as well. And lots of legal eyebrows have shot to the heavens upon reading that paragraph. But so a deputy it doesn't affect the content of a deputyship order, right? Deputyships should just carry on doing what they're doing.
Okay, thanks, Oliver. I think I'm going to call it there because we're going to overrun and the questions are still coming in thick and fast. I suggest we probably hold another one of these in a month's time, and we can certainly. There's been a couple of things I'm taking away about capturing stories. That will definitely link through Oliver through the Rightful Lives group. Final words. Let's go, Demi, Gail, Oliver. Final words for people on this call. Demi.
A lot to discuss, a lot to think about. It's been a really helpful session. Not necessarily a plug, but Gail and I do hold an RPR/DOLS subgroup. So things that we've talked about today in terms of a sector response, a sector call to action, they are definitely things that we can take back and discuss as part of that group. That subgroup is a subgroup of the Leaders Network. So obviously anyone that's involved in that is welcome to join us within that group. And yeah, like you say, things that we've discussed today, we'll definitely take back and reflect on in that group and see what we can put together as a sector response.
Thanks, Demi. Gail?
Yeah, so as Demi says, we're starting to think about how we pull together a sector response that we share. Kate, I'm sure we can share contact details for how people can contact Demi and I to contribute to those. I guess it's kind of gird your loins. I think it's kind of, we've got to get through this next phase, and I keep seeing lots of questions about, well, what are we doing with this bit, and what are we doing with this bit, and what happens with the, we don't really know, but we do know that the law applies now, and I guess we've got to start, haven't we, applying our critical thinking to the people that we're supporting, and finding ways of trying to make that work as much as possible. So kind of, but I also think kind of that back to kind of demonstrate your impact, show your value, show your worth, so that we can keep that resource in the sector as far as possible, so we can carry on standing alongside people.
Thanks, Gail. Oliver?
Two things. Please think of a really, really good impact case study, a real life example that you've been involved with, where you've got some sort of success from the Court of Protection in a case where now that person might not be described as being deprived of their liberty. And Kate hopefully will be able to send around the link, which hopefully I think will go up today. So
Awesome.
please, yeah, do that. And secondly, please galvanize into a sector-wide call for action, and make it like a positive call for action, which hangs on something in the Supreme Court judgment. I would, and I'm very happy to, and I know loads of other lawyers, very happy to work with the sector on figuring out what Article 8 safeguards really mean, what it could look like, and what are the legislative changes in the Mental Capacity Act to potentially widen the scope of IMCAs into that space. But thank you very much. I found it very interesting.
Thanks, Oliver. My final plea would be, don't be passive. This is, we are strong together. You've got really powerful voices. People have got powerful voices when you amplify them. So keep doing what you're doing. And yeah. Is this where we sing the Natalie Bedingfield song? We gotta get through this. We gotta get through this. What's that song? I've got it in my head. We gotta get anyway. Okay, guys, we will do another one in 4 weeks' time. Keep talking. We are a community. You're not alone. So keep in touch. And yeah, all is not lost. Take care. All right. Thanks, guys. I'll just stop recording.